Assalamualaikum warahmatullahi wabarakatuh. My name is Maradona from Faculty of Law, Universitas Airlangga. It is an honor for me to present my paper in this conference. My paper title is Criminal Law Response to the COVID-19 Pandemic in ASEAN, a study on the effectiveness and the limit of criminal law. As already we know that COVID-19 was declared as a global pandemic since March 2020. Since then, every government in this world have enacted few policies on health security, such as movement restriction and health protocols involving criminal law regime. But some people still continue to disregard these policies. The general reason for the violation of government policy on COVID-19 arose from several factors, such as knowledge on COVID-19 and also economic and social needs. The statement of problem with this paper will be the criminal law punishment was deemed as efficient and necessary to lower the number of offenders. However, this policy has also a potential to violate toward human rights. And then, what is the extent and the limit of criminal law sanction that can be used to regulate people's behavior in the pandemic era in relation to the people compliance with the health protocol and the human rights dimension of COVID-19 response? Criminalization is shaping social behavior. Beccaria in the crime of and punishment, he said that principle of punishment arises out of the belief that people want to achieve benefit and to avoid pain, and thus the level of pain must be higher than the benefit for people to avoid violation. In the term of criminalizing act, it should consider intrinsic values such as justice, fairness, right and wrong associated with whether there should be deterrent purpose or retributive purpose or even approach to punishment. In addressing the issue of COVID-19, an understanding of the core issue of the pandemic is needed in order to establish effective health policies, including how criminal policies can further assist the implementation of these health policies. Public knowledge of COVID-19 has greatly affected people's conduct of the health protocol, and it is necessary to ensure that people have received the sufficient amount of information about the COVID-19 before making any criminal policies. In the right to life, the right to health, right of liberty, and also the right to work have tied closely with the existence of COVID-19 pandemic. Under the right to live, for example, the country has obligation to ensure that the countries have encompassed the foreseeable threat and made measures concerning life-threatening diseases. The methodology of this paper was a normative method that overview policies concerning the COVID-19 pandemic and looking at 3 countries in ASEAN in relation to the punishment for violating the health protocol within those countries and its effects on human rights. The COVID-19 pandemic has forced the countries to make extraordinary policies to maintain the health and well-being of its people. Aside from health protocols, the government has also enacted policies about punishment under criminal regime, starting from fine to the deprivation of freedom. In Indonesia, for example, in general, it has comprehensive policies concerning the countermeasure for COVID-19, including the criminal punishment. However, the implementation of criminal punishment within those policies has been inconsistent and created a legal certainty for the parameter of violation. One of the examples of the enforcement was in the case of Habib Rizik, where he was charged with 4 years in prison with a fine of 2,000 million rupiah for creating a crowd in the middle of an outbreak, compared to weak response to several political actors who violated the similar law. So it's about the inconsistent and the question on legal certainty. On the other hand, the approach taken by the Philippines government has been characterized as securitization. This characterization came from the observation of military and police-centrist approach. Malaysia has also implemented criminal punishment to the offender, but the decision to jail protocol violator has also led to the controversy. The adherence of the people is based heavily on the understanding of the people about the virus. Therefore, the number of violations is affected more with the understanding owned by the people and not the existence of the criminal punishment. The violation of health protocols are generally driven by the need to fulfill their economic necessities, in which the benefit of people violating the policy is higher than the pain of punishment. The government must give regards to the economic necessities of the people when enacting the policies concerning movement restriction, as it is the main factor that will affect the effectiveness of policies implementation. Due to the COVID-19 policies, it becomes a burden for some people as their usual activities or future plans are limited. The result of this is the policies have not been seen by the people as something important, and thus criminalizing an act and giving criminal punishment to offender will not change the number of violations. Under international human rights law, countries have the obligation to make policies that are based on scientific evidence and align with the human rights standard. This is the reason that policies under criminal law also have implications for human rights. In times of pandemic, policies concerning the standard of health are the most relevant. The standard of health that must be fulfilled within this provision should encompass more than only that of a physical, mental, and social well-being, but also social economic factors that promote conditions in which people can lead a healthy life. When aligning the policies with international human rights law, the government must consider how the policies of criminal punishment would have a legitimate aim and also necessary and proportionate to the aim pursued, in which also did not burden the society through their limited economic sources. The element of necessity within a criminal law is ultima ratio, meaning that the punishment is only implemented in the most severe circumstances, and there exists no less intrusive alternative that is effective to reach the legitimate aim. Within the realm of human rights, the government must fulfill the strict proportionality test. The principle of proportionality within the present time can be seen from three main aspects. A, whether the provision enacted by the government is suitable to achieve the aim to decrease the number of infection. B, whether the benefits are higher than the burden held onto the people, and whether it is absolutely necessary. As a conclusion, yes, indeed, that the number of criminal law policies' effectiveness came from the scale of benefit to the pain of punishment, in which higher pain than benefit would raise the effectiveness of the punishment. However, in creating criminal law policies, the government must consider the needs of their people, including the economic necessities and people understanding of the COVID-19. The enactment of severe punishment without proper scientific data has the potential to violate human rights law, as the punishment is not necessarily proportionate and it is not in accordance with due process of law, both in making of and implementation of policies. I think that's all of my presentation today. Thank you, and please, if you have any question. Wassalamualaikum warahmatullahi wabarakatuh.